Justice Jackson?
So I think I read Algonquin differently than Justice Kavanaugh. When I look at its analysis, it absolutely does a textual review, but then it says, quote, turning from Section 232's language to its legislative history, again, there is much to suggest that the president's authority extends to the imposition of monetary exactions. And I appreciate that perhaps that factor is no longer in vogue, but did you look into the legislative history here to determine whether there is anything that supports the conclusion that Congress actually intended for this IEPA statute to allow or authorize the president to impose these tariffs?
I did, and if I blinked, I would miss it because it was virtually nothing. And in fact, both page 2 of both the House and Senate report outline all of the powers that are given under IEPA, and none of them have tariff. There's one brief mention of tariff in the legislative history, but nothing else. And by the way, IEPA passed by voice vote. It was, there was not controversial. We don't deny IEPA as a big, major statute, but the question is, did it authorize tariffs? One of the most contested things since our founding.
And you say there's nothing in the legislative history to suggest it. Now, to the extent that Congress did authorize the president to do something, that those verbs are there, that the Congress was giving the president some authority, do you see a theme connecting those verbs? What was Congress trying to do? And let me just say that I see in the Senate report, which I mentioned earlier, that Congress says that it was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And that seems to dovetail with the verbs that are being used in the statute, but what's your view of what Congress was trying to do with this legislation?
That's exactly right. They're responding to all sorts of foreign policy emergencies and foreign threats, and they're giving the president economic sanctions power.
So what does the word regulate importation do under that framework? If we understand that Congress was trying to give this kind of embargo authority in the time of an emergency, when it says regulate importation, what was it envisioning?
It was envisioning all the things that the president since 1977, going back to Justice Kavanaugh's question, have used it for. So they've used it for quotas, like limitations on the number of goods. They've used it for screening and reporting requirements, like Executive Order 12284 about reporting property of the Shah. And they've used it for standards, like domestic safety standards, environmental standards, labor requirements. They've used it for embargoes. So all of those are things that I think Congress had in mind in IEPA, and I think the proof of this, that it's not this massive statute that allows the government to do anything, is Dames and Moore itself, because this court rejected the idea that regulate includes the claims extinguishment that was at issue in that case. It's a much more limited statute. And Justice Jackson, there was a predecessor, Justice Jackson, who said, that, quote, for all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of this court to be last, not first, to give it up. And I take it my friend's argument on the other side is in deep tension with Youngstown and that canonical principle.
Thank you.
Thank you, counsel.